You've probably heard the phrase non-compete agreement, or maybe you've been a party to one. What exactly is a non-compete in plain English? When are they enforceable? What's the deal? Let's get into the nitty-gritty. Hi, friends. Welcome back to Life is Legal, where we unpack the laws that sneak into everyday life without the Latin, the lecture, or the stodgy lawyer vibe. I'm Brooke Hardy, lawyer and legal translator, and today I am thrilled to welcome someone who knows a whole corner of the law most people never think about until it shows up in their life in a very big way. You've probably heard the phrase non-compete agreement, or maybe you've been a party to one. And our guest today, Zach Wolfe, has spent over 27 years navigating exactly that world. His blog, 5 Minute Law, and his YouTube channel, That Non-Compete Lawyer, make complex workplace disputes surprisingly understandable and relatable, and honestly fun. Zach Wolfe helps people and businesses figure out what their rights really are when jobs, contracts, opportunity, and litigation collide. So, Zach, welcome to the podcast.
Thank you, Brooke. I'm really excited to be here. I did come prepared to be stodgy, but it sounds like you don't want that.
No, at least you have the top button unbuttoned. So, in a purple tie, not just a blue or red.
Yeah.
Okay, good. So we're off to a good start. All good. Zach, let's get into the nitty-gritty right off the bat. What exactly is a non-compete in plain English? When are they enforceable? What's the deal?
Yeah. Great questions. Well, okay, what is a non-compete? That question is actually surprisingly difficult in the law sometimes, but let me just put it in practical terms for the average person. For the average person, a non-compete is part of an agreement that restricts what you can do after your employment ends. And I'm talking about an employee non-compete. There are other kinds of non-competes, but that's the most common kind, so I kind of default to that. And an employee non-compete, like I said, it's going to be an agreement. It restricts what you do after your employment ends. So the most common things would be it restricts whether you can work for a competitor. It may restrict whether you can solicit clients or customers. It might restrict whether you can solicit or recruit employees of that employer. Those would be the most common features of a non-compete.
The poaching of current employees. Gotcha. Okay. And who do they apply to most? I mean, are they upper level, C-level people mainly, or is it all the way down the chain? Where do you see them most often?
Yeah, well, the classic type of employee who it makes sense for them to have a non-compete would be the salesperson, right? Sometimes I call it Sally Sales on my blog. If you're a Sally Sales, somebody who is out there trying to bring in business, who has clients or customers she has developed goodwill with, who maintains relationships with customers, sometimes we call it a customer-facing employee. That's the classic case where a non-compete kind of makes sense because the employer is trying to protect the employer's goodwill with those customers, right? Now, you also see them for the higher level executives. That works a little differently because the rationale there is a little bit different. It's more about protecting the confidential information that high level executive knows. If somebody's high up in management, they're going to know just about everything there is to know about the company. And the concern is, well, I don't want them leaving and going to work for my fierce competitor and sharing all that knowledge. So you see them there as well. Now, unfortunately, increasingly you see them for lower level employees or back office employees who are not customer facing and are not high level executives. And in my view, it doesn't really make sense for those kinds of people. You still see them though. I get clients, we get hairstylists, for example, who have signed non-competes. I had a non-compete case where my clients were, assistants to behavioral therapists who got paid like $17 an hour, and they were made to sign non-competes. So more and more employers are requiring lower level employees. And when I say lower level, I don't mean that to put these people down or anything. I'm just saying they're kind of at the bottom of the organization. And in my view, that's an unfortunate development. But anyway, that's we could go off on that for a while. But as I said, coming back to the classic case would be the employee who has relationships with customers.
Mm-hmm. It just, a lot of people I've heard in passing say, oh, don't worry about non-competes. They're not enforceable. They're not. And on the one hand, it does, just the general thought of keeping someone from making a living doing what they know how to do and what they're good at seems wrong. And yet you can see, the employer side of it as well. So obviously you got to rein it in sometimes. And I know there are some, there's some scope issues, geography issues. So paint the picture on what, in your mind, a fair non-compete might look like.
Sure. Well, there are two ways that people usually go wrong in thinking about non-competes. And you hit on one of them, which is thinking, oh, non-competes, I've heard those are just not enforceable. Okay. Or you'll hear this phrase, well, Texas is a right-to-work state, so they can't enforce a non-compete. So let me talk about that real quick. So first of all, right-to-work has nothing to do with non-competes. When people say right-to-work, that has to do with collective bargaining and unions, okay? It had nothing to do with non-competes. So if you're thinking about non-competes, put right-to-work out of your vocabulary, okay? Now, so non-competes can be enforceable, and you should not just brush it off thinking, oh, I heard non-competes are unenforceable. On the other end of the spectrum, you get people thinking in very simplistic terms along these lines. My employee signed this non-compete. It says he cannot work for any competitor for a year after leaving. He's working for a competitor. Therefore, judge, I'm entitled to a court order that says he cannot work for that employer. Wrong. That is too simplistic. It is not that simple. It's not just a question of what does the contract say and what is the employee doing. And that is because under the law in Texas, as in most states, there are limits on non-competes. And the simplest way to put it is that a non-compete has to be reasonable in scope. And to get more specific, what Texas law requires, and again, like most states, it has to be reasonable in time period. It has to be reasonable in the geographic area it covers, and it has to be reasonable in the scope of activity it restrains. Now, people will usually focus on the time period and the geographic area because those are pretty easy to understand for the average person. The scope of activity part is actually, in most cases, the most important part. And that's probably, in my law practice, what we end up arguing about the most.
Mm-hmm. It sounds like, okay, if it's not, you can't just go work for a competitor. It sounds like you've got to look to the spirit of the non-compete. What is the actual harm to your former employer that they're trying to protect against? Is that sort of what you get into when you're arguing these cases? Is, hey, I know on paper, yeah, they're a competitor, but they're actually not being hurt because of X, Y, Z. So talk to us a little bit more why it's more complicated than it seems sometimes.
Yeah, that's exactly right. So when we talk about the scope of activity, a typical scope of activity might say something like, you may not be employed by or consult for or work for anyone who is a competing business. And then they will define a competing business essentially as anyone who does the same things we do. Okay. That is sometimes known as an industry-wide exclusion, because basically it's saying you can't compete with us in this industry for some period of time and in some geographic area. Texas law generally says that that's too broad. And I say generally because, of course, there are always exceptions. And in my world of non-compete law, our basic standard is reasonableness. And of course, reasonable is a very fuzzy standard, right? You can't really draw precise lines as to what's reasonable. So that's why I say generally. But as a general rule, you can't have a non-compete that broad. And the reason for that is that it goes beyond what a non-compete is supposed to do. Well, this is sort of counterintuitive. And I had a judge ask me, well, isn't the point of the non-compete to restrict competition? Which sounds obvious. I was like, no, actually, no. That is not under the law what a non-compete is supposed to do. It's not supposed to just sort of simply restrict competition. It's supposed to protect confidential information and goodwill. Those are really the two interests that a non-compete is supposed to protect.
Kind of a misnomer then. We need to rename these types of agreements.
Yeah, I think so. That's right. So it's not about trying to stop somebody from competing with you. It's about stopping somebody from using your goodwill with customers to compete with you.
And by goodwill, you're talking about good reputation that company has built along the way. So in other words, it sounds like, when you have a non-compete, and stop me if I'm wrong, but I could have a non-compete and technically compete over here. But if I am servicing customers that this company that I used to work for would never have serviced or were not going after or whatever, even though I am competing because I am doing what my non-compete says I can't do, but then I hire a slick lawyer like you that says, hey, it may be competing, but this employer is not being hurt. The point is to protect their relationships, their customers, their goodwill, their good reputation. And if Brooke's over here doing this and it's technically competing, but they're not being hurt, she probably hasn't violated that non-compete.
You nailed it. That's it. Yeah, that's exactly right. And let me take the flip side of that, which is, let's say I'm going to use a common industry in my field is like insurance agents. Okay. Let's say you're an insurance agent and you've got 300 customers who have their insurance coverage through you, right? And that's your book of business, so to speak, right? And if you leave one insurance agency and go to another and 290 of those customers renew with you at your new employer, that's the kind of thing a non-compete is designed to prevent, right? And I sum this up. I call this Wolfe's first law of Texas non-compete litigation. And that is, I got it down to 7 words. You can't take your customers with you.
Right. Rule
okay.
1. You can't take your customers.
Now, conversely, if you're not taking customers with you, you should be allowed to compete. That's the basic distinction.
Because people need to eat. People need to continue to work. We don't want to be...
Well, there's that. Yeah, that's right. People need to be able to make a living, but also it's in the public interest, right? We want competition, right? We want people to be able to leave and go to work for a competitor. That helps everybody. Now, I will hasten to add that so far we're kind of just talking theory. Right. You're talking about like what's the rationales that are in the case law and in the statute. And that's all theory. Now, in my practice, we don't just deal with theory, we deal with reality, right? In practice, if there's a lawsuit and if your former employer is trying to prevent you from working for a competitor, a human being is going to decide that dispute. A human being called a judge, right? Most of the time, maybe an arbitrator in a few cases, but most of the time it's a judge. And like I said, judges are human beings. They are not legal doctrine robots, okay? And I hopefully there are no judges watching, but what if I told you that judges don't always understand the law? Number one. Number two, what if I told you sometimes they might understand it and they don't care? Okay, right. Shocking, I know. But I'm just talking from experience.
Yeah.
You know.
And so are you saying that some are pro non-compete enforceability and some are against non-compete enforceability and it's just kind of the luck of the draw, or?
Are you sure this isn't your practice area?
I'm positive. Asking for a friend.
Yeah, no, that's exactly the situation. There are two big factors that are going to determine what happens if you get sued for violating a non-compete. The one is what you just touched on, which is, I'm going to call it the worldview of the judge you happen to draw. You can maybe say the ideology but the worldview, and it doesn't necessarily line up along partisan political lines, but it's going to be, what does that judge think about non-competes?
Right. And
that judge generally
have dealing with them on their own. That all creeps in. I'm sure that's not what people want to hear because.
It's right.
Yeah.
Right. People are going to come to this with their own preconceived notions. That's why we have jury selection, right? Everybody understands that. Well, judges are people too, right? And if you were selecting a judge for your case, you'd want to know, what are their sort of preconceived notions? Did they spend their legal career defending employers in lawsuits versus did they spend their career, representing employees suing employers, or maybe something totally unrelated to any of that? That's going to have an impact on how they look at it, of course.
Okay. Then, Mr. Good Lord, that's not great news, Zach, but it is real. It's the truth. And so let's backtrack a second then and say, okay, so that you don't find yourself in a lawsuit, or pre-settlement stuff, which we'll get into, and splitting hairs over the finer details. What can people do on the front end when, okay, maybe it is reasonable that they be asked to sign a non-compete and it's not a showstopper of a thing? What are some red flags people should be on the lookout for? And can you negotiate a non-compete, or is it usually employer says this is it, you have to sign it if you want the job?
Yeah, well, let me take that. I'm going to go in kind of reverse order. I'm going to start with what you do at the end of the relationship, and then I'll come back to the beginning of the relationship. Okay, so the end of the relationship gets to the second factor that really determines what's going to happen in a lawsuit. And that factor is, do you have what we call a clean exit? And we talk to clients about this all the time. Sometimes we talk to clients before they leave and we explain what a clean exit looks like. That's the best time to talk about it. Sometimes we represent a client after they've already left and they've had a messy exit. And then we're just doing damage control. But let me explain clean exit versus messy exit. In a perfect world, here's what a clean exit would look like. The employee gives their notice of resignation. Now, sometimes they'll be asked to leave immediately. Other times they may stay on for a week or two. Okay. Let's say they give their notice, and on their last day of work, they come into the office, they say, here are my keys, here's my company credit card, here's my laptop, here's my company phone, and whatever other stuff they have. And they leave and they have nothing, no documents from the company whatsoever. Okay. With the possible exception of it's generally okay to keep a copy. Like if you have an employment agreement with the employer, I think you can keep that. Right. Or if your payroll records, for your taxes, you can keep that, or your health insurance records. There's obvious stuff like that you can keep, but nothing else that belongs to the company. Now, people will get tripped up, and this is just human nature, and it's common to think this. I'll have clients where they'll say, oh, no, I don't have any of their documents. And then we'll start talking, and they'll mention some document. I'm like, wait, I thought you said you didn't have any of their documents. And they'll say, oh, no, that's my document. I created that. And then I'm like, wait, well, did you create it while you were working for them? Oh, yeah. Okay, that's not your document. In their eyes, that's their document. Anyway, so in a clean exit, you don't have any of their documents. And also, you haven't put their documents on a USB drive that's sitting in your drawer at home. You haven't emailed their documents to your Gmail account. So that when you leave, you don't have any of their stuff. That's part one of a clean exit. Part two is I'm going to use the words, I have a lawyer friend, Susie Lehman Johnson, who I've worked with on other cases. She calls it throwing things over the fence.
Okay, what is that?
Okay, that's like where, let's say, I'll go back to my insurance agent example, okay? If I start calling up people whose renewals are coming up, and I'm like, hey, before I leave, I'm like, hey, hold off on that renewal. I'm going to be somewhere new in 2 weeks, and then I'll take care of you. Okay, that's throwing stuff over the fence, right? And that's a no-no, okay? That's a messy exit. You don't want that. You don't even, again, in a perfect world, you wouldn't even tell any of your customers or clients anything about leaving until after you leave. Now, that's hard to do, especially when you have personal relationships with people, right? Like I'm sure you can imagine when you're leaving a law firm, are you going to wait until the day after you left to tell your longtime clients you've left? Probably not.
Probably not. I know, right? And I feel like clients or customers deserve to know. But yeah, it's a fine line that you've got to walk, But Zach, I want to ask you something on what you said about the clean exit and making sure you don't take anything. Now that is not, that doesn't really have to do with a non-compete that you may have signed, right? That's getting into taking company information, not going to work for a competitor. So talk a little more around that.
Yeah, well, that's a good point. And it gets to the practical side of this, because from the standpoint of just pure non-compete law, it shouldn't really matter whether you took their documents or not, right? But from a practical standpoint, if I'm going into a courtroom to see a judge on a TRO, temporary restraining order, or a temporary injunction, where the court's deciding whether to issue an order to stop somebody from working or competing, if I go in there and my client and I'm representing the employee, which is my typical role, or I'm representing the company that hired the employee, and the former employer comes in and says, Judge, look what we've got on this guy. The last day of his work, he downloaded our entire customer list and emailed it to his Gmail. He put our last 12 months of sales reports on a USB drive 2 days before he left. Think about it. The judge is human. The judge is much more likely to restrict that employee compared to somebody who didn't take a thing. Right? So that's where the sort of the trade secrets and confidential information area of law intersects with non-compete law.
Right. There are two different causes of action, two different ways to get sued, but it sounds like they oftentimes can go hand in hand, and that's not a good thing. Okay.
Gotcha. That's right. And I'll add this along that line. even if you don't have a non-compete, if the employer can seek essentially the same thing on a trade secrets theory. They can say, you know our trade secrets, and therefore you should be restricted from competing. And this happens all the time. And my clients will say, wait a minute, I never signed any non-compete. How can they stop me from competing? Well, you took a bunch of their documents and they're claiming that that's their trade secrets. That's how.
And that you're going to use those in your next job, and that is competing in a way that's not violating a non-compete that you signed, but violating their rights as the owner of those trade secrets then. Okay. Or confidential.
That's right. That's right.
Okay, well, how do I do this? How do I like, I'm sorry, I learned that on the job. I have that knowledge now. Are you saying now that I can't take my brain over to this job and that I have to use only the stuff that I didn't learn at that other job? How does that work?
Yeah, that's a distinction that we argue about all the time in our practice. The distinction is an employee is allowed to use her knowledge, skill, and experience. Okay, so we'll call it general knowledge, skill, and experience. That's the phrase you usually see in the case law. So you can use that, because otherwise, if you can't use that, what are you supposed to do?
Yeah, exactly.
Right? Now, what you can't do is take your former employer's confidential information or trade secrets, and we can get into what's a trade secret later, but you can't take that kind of thing.
They're secret sauce.
Yeah. Now, where's the line between those two things? That can be difficult to draw, obviously.
And that's what keeps guys like you in business, you know? Yeah. Right. It's a fine line. And how does all of this, how have you seen your area of law change and or grow in this era of remote working, you know, and the whole geographical, well, and I may be getting ahead of myself, but, you know, you mentioned the time limit, the geographic area, and the scope of what you're prohibited from doing as being three of the factors. So many people are working remotely now. So many businesses, you know, the onset of websites, for heaven's sake, are geographically, 50 states plus DC. How does that play into that limitation, the geography of a non-compete?
Yeah, I hadn't really thought about it in those terms, but I can think of two things that have changed. And let me back up just a little bit in terms of, where my practice has been and where it is now. I started off in kind of just a general business litigation practice, which included non-competes at times. I didn't really start to specialize in this area of law until about 15 years ago, roughly. And that's when I really started to focus my practice more on these kind of cases. And I actually started my own firm in the middle of the pandemic. So this remote work issue really was with me from the start of when I really started to specialize in this area. One way that I think it has impacted my practice is, as you mentioned, the geographic area concept. And it's a very old-fashioned concept. In Texas, and people, thanks for mentioning the blog, 5 Minute Law. I've got a post, I think it's called Jurassic Non-Competes, that goes back to the very start of Texas non-compete law, and mainly cases from the 1920s. And guess what industry they were mostly about? You'll never guess, but
Or, I don't know, what would it be?
Ice delivery, right? Well, I guess it's still a thing to some extent.
Yeah, maybe that's when ice was invented. I don't know.
It's when guys would start, it's probably when they first had refrigeration that they could drive trucks around and deliver. So ice delivery people would have non-competes. And the courts would say, okay, you can restrict the ICE delivery man from the territory that he serviced, but you can't restrict him outside of that territory. And the rationale was that's where his customers were. The people who knew him, hey, that's my ICE guy, right? So and the same concept applies today. The problem, of course, is now, how do you apply that when people are working remotely? And especially like in services businesses, like let's say I get a lot of financial advisor cases. Like a financial advisor could be in Singapore or something, and it wouldn't really make much difference, right? To some extent. On the other hand, there's still something about being local and like physically seeing people. I had an accountant client with a non-compete case, actually went all the way to a jury trial. And, I was that case reminded me that physical proximity still can be important. He was in a smaller Texas city, and he was telling me how some of his clients didn't like it when he went to a big accounting firm that had like a 4-story building. And that was big to them. They were like, they wanted to just walk in on the first floor and talk to their accountant, and they want to see him face to face. So it still matters in some fields, but in many fields, like, where people work remotely, it changes the whole geographic proximity issue.
Totally. And speaking of the pandemic, I'm thinking of, a service, let's say, a business coach, who started his or her own business online during the pandemic, say, and they may have clients in 30, 50, 60, 70% of the states, because I can coach you. I don't need a license to be in that state, et cetera. And so if I have an associate that works under me and I have this business and I'm servicing people all over the country, I would think that my non-compete that I'm going to have them sign is going to be nationwide. Whereas, and limited in the right amount of scope, and for the year or two that seems reasonable. But it seems to me that people are not going to be able to just go move to Colorado and hang out their shingle as easily as maybe they once were able to do, If it is a business where you don't need to see someone in real life, but you can service them from wherever, it seems like that would be a benefit for the employer going forward.
Yeah, funny you mentioned that. Believe it or not, I had a business coach client with a non-compete dispute. And yeah, that was part of the dispute. Just to show how far non-competes have permeated, all kinds of industries. But yeah, it does complicate things a bit. The other thing that I think I've noticed coming out of more remote work is just the practical issue that it provides more opportunities for employees to commingle business documents and personal documents.
Oh, right.
Right. If you're working on a laptop at home all the time, most people are not going to keep 2 laptops, right? Now, if they came to me for advice and, if they have a non-compete or they're in an industry where the employer might try to stop them from working somewhere else, I would say get 2 computers. Keep all your personal stuff on one computer, your work stuff on another computer. Do not let them commingle with each other. Because otherwise what usually happens, and this is what most people do, when it's time to leave, earlier I said, in a perfect world, the clean exit, you just hand over the laptop. Well, most of the time that can't happen because they've got their family photos on there. They've got their tax returns. They got their mortgage application. They got, who knows, their health insurance, records. And so they need stuff that's on there. And that creates problems when there's a messy exit. So that's the other way I've seen it kind of affect my practice. I would even tell people, ideally you would even have 2 phones, but very few people are going to go to the trouble of having a personal phone and a work phone.
Why do you say that? Why is the phone important also?
Well, because it's just so easy for work-related documents to get onto the phone, even if it's your personal cell phone, right? I mean, just a basic example would just be the contacts on your phone. In many cases, in the lawsuits we handle, the employer will claim that the list of contacts, that's a customer list in their eyes, and it's confidential. Now, 95% of the time, it's really not that confidential, but still, they will argue that. So,
Even text messages, texting company information back and forth, you take off with all those texts, that could look bad.
Right. Oh, I'm glad you mentioned text messages. Text messages, they're kind of like what emails used to be. It used to be people would say stuff in an email that they wouldn't say in a letter, right? And you're like, oh, why did you say that in this email? Well, I think people have kind of figured out, I better not say that in an email. Now it's like they'll say in a text message what they wouldn't say in an email. And people don't understand those text messages are going to be evidence.
People need to do the judge, grandparent, employer role. If I'm embarrassed for a judge, my grandmother, and my boss to read this, I probably shouldn't send it.
Yeah. I think we'd all be in trouble on that. But no, you're right. That's the
I'm acting like.
Yeah, no, that's the idea. If, for example, here's a common scenario. A common scenario is more than one employee leaves an employer at a time. And often they talk to each other. And sometimes they might go to the same subsequent employer, or they might leave and start their own new business, 2 or more employees. And they're going to talk to each other about it before they do it, right? And a lot of times they're going to text each other about it. And that's generally a bad idea. So if there's one thing, I mean, the first thing for people to remember is clean exit, don't take documents. But also remember, if you're making plans to leave and compete, anything you text or email or WhatsApp or whatever, that's going to be evidence. So it's better just not to do that.
Yeah. And in evidence, even if it's on your own personal phone, I think.
That's right. That's right. Now, that leads to people doing dumb things like wiping their phone, right? Now, and people, they'll always think they're smarter than everybody else and will do stuff like that. That makes it worse, okay, in a lawsuit. Because in a lawsuit, then here's what happens. Let's say you got text messages and you delete the text messages because you don't want them to be evidence in a lawsuit. Many times many text messages get deleted the day after a lawsuit is served. In my world, and here's the thing. Usually the text messages probably weren't that bad, but guess what? When they find out you deleted the text messages, then the employer is going to say, well, all the evidence was in those text messages. All the evidence we don't have, that you conspired to steal our information, all that evidence, that was all in the text messages that you deleted. That's what their lawyer is going to argue.
Yeah, definitely. And for listeners who are not lawyers, if you delete evidence, text, get rid of documents, whatever, emails, after there's a possibility of a lawsuit, certainly after you've gotten served, to delete all of that is against the law, spoliation. So.
Yeah, it's called spoliation of evidence, and I mean we fight about that. And I would say at least half of our lawsuits.
Good grief. So just don't put it in writing to begin with, and then don't delete anything and show them you didn't talk about it.
Yeah. And to make it even simpler, don't do anything that you would need to communicate about anyway, right? Now, sometimes it's unavoidable. And generally, the law does allow employees to make plans to compete with their employer. Again, as a general rule. So it's not necessarily wrongful to say to yourself, okay, I think maybe I want to start my own business doing this, and to make preparations for that.
Right. There's a right way to do that.
That's right.
Yeah.
That's right.
Yeah. Tell us a little bit for folks who will be faced in the future with a non-compete. Give us some tips on what you think are reasonable terms, things to look out for, because they are part of the world, and more people are facing them now than ever, I think. And so what are some red flags? What are fair terms? And I know it depends on the industry and the business and all of that. It's an unfair question of me to ask you, but what are some...
No, it's fine. No, and we deal with this question all the time. Let me start with this. I tell people that generally you should not sign a non-compete because they can be enforceable and they can have real teeth and they can really make your life difficult. There are 3 exceptions to that, 3 good reasons to sign a non-compete, okay, that I tell people. The first one is if it was part of the deal, okay? If your employer offered you a job and made it clear, okay, part of the deal is this 1-year non-compete or this 2-year non-compete, okay? And if you agreed to that as part of the deal, then I think it's reasonable for them to ask you to sign it, right? But that's not what happens in most cases, of course, right? Most of the time, somebody gets a job offer. There might even be an offer letter. Nobody says anything about a non-compete, and they show up the first day for work and they get a packet, an onboarding packet. Sometimes they'll get it electronically now, and they have to sign all this stuff. And the employer will put a non-compete in there like it's providing an I-9 or something. Like this is just routine, I mean, that's the way you usually have. Sometimes the employee doesn't even remember they signed a non-compete. And that's wrong. That should not happen. And, to get on a soapbox for just a second, I mean, Texas legislature, if you're listening, somebody ought to do something about that. I mean, that's just wrong. Okay, but putting that aside, that's, if it was part of your deal, okay. The second reason to sign one, in my view, is if they're paying you for it, okay? So let's say they have a 1-year non-compete and they're going to pay you a year of severance if you're let go. Or sometimes a scenario you often see is your company gets bought out, or merges, and as a retention deal, you get like a big retention bonus, and there's a non-compete tied to it. So if you're getting $200,000 to stay, and they want you a 1-year non-compete as part of that deal, that might be reasonable. You might say, okay, if I have to not compete for a year, but I'm getting this money, maybe that's reasonable. If they're not paying for it, I would push back and say, wait a minute, you're telling me you want me to sit out from the industry for 2 years? Are you going to pay me for that? And if the answer is no, then I would say, I'm sorry, I can't agree to that.
Right. And can they fire you for not signing it later if they say, you know what, now we want you to sign this, and if you don't, you're going to have to leave? That's a tough situation to be in.
It is. Well, that's the third reason to sign one.
Oh, I just stole your thunder.
That's the most you gave me the perfect segue. If you have no choice, and that happens a lot. I mean, yeah, and the answer is yes. They can fire you, assuming it's at will employment, which it is 95% of the time. But yeah, if it's at will employment, they can say, oh, well, if you're not going to sign this, sorry, deal, offer rescinded, I mean, that's the reality of it. And the other reality that we deal with a lot in our practice is that a lot of times, this is getting to your question of what are the terms, the red flags that you should look for, that sort of thing. We can definitely help people with that. But a lot of times it's just take it or leave it, right? Especially with larger organizations where they've had their their in-house legal team or maybe outside counsel even has drafted this employment agreement, and they're not going to entertain any changes to it. So that happens a lot. Now, if they will entertain changes to the non-compete, obviously you want to look at the time period. You might want to push back on the time period. You might want to push back on the geographic area. The scope of activity is the more difficult one, and you probably want to get a lawyer involved in that if that's going to be an issue, how that's worded, because that can be kind of tricky. Now, one kind of funny dilemma we have in our practice is, well, would we rather the employee have a non-compete that's clearly overbroad and unenforceable, or would we rather they have a narrow one, that's more likely to be enforceable, right? And you can kind of go either way on that. And I'll turn it around. If I'm representing the employer, and sometimes employers will engage us and ask us to draft a non-compete, which I don't really like to do because I don't really like them, but I'll, if they twist my arm, I'll do it. And the thing that I tell them that's a little bit counterintuitive is, look, you want to make it as narrow as possible, because the narrower it is, the more likely it's going to be enforced, right? If you make it super broad, a judge is going to look at that, and that some lawyer like me is going to have an easy time arguing, oh, that's clearly overbroad and unenforceable. Mm-hmm. So,
and that takes a lot of money to have that fight, and then have a judge potentially narrow it down anyway, too.
That's right. And you're getting to the concept of reformation, and maybe we should talk about that.
Mm-hmm. Sure, go for it.
Yeah. So if you look into non-compete law, you're going to hear this concept of reformation, which essentially means rewriting the contract. And in non-compete land, that means narrowing the non-compete to make it more reasonable. And different states have different approaches to this. Texas is generally pro-reformation. It basically, the statute says that if the non-compete is too broad, the court shall reform it. So it's even stated as a mandatory thing that the court will do this. And so that's Texas law. Here's the thing. This gets back to the distinction between practical and theoretical. You almost never get a judgment of reformation from a court in a Texas lawsuit. I've handled dozens of non-compete lawsuits. I don't even know if I can think of one where there was a final judgment of reformation.
Really? They just either honor them or kick them out, even though the statute says you shall reform?
Well, here's what happens. Usually where the fight is on the temporary injunction, which happens before there's a trial and before there's a final judgment. That's usually where the decision is made to enforce or not enforce, and to what extent are you going to enforce. And on a temporary injunction, the judge can do whatever the judge wants. I had a case where I was arguing the non-compete was overbroad. There was very experienced and effective counsel on the plaintiff's side trying to enforce the non-compete. The judge initially said he wasn't going to enforce it, but then he changed his mind and he said, okay, here's what I'm going to do. Plaintiff, you tell me the 10 clients you want restricted, and I'm going to restrict the defendant from doing business with those 10 clients. Okay. Now, why 10? Is there something in the law that says 10? No, it was totally arbitrary. It was just the judge trying to find some compromise that he thought was reasonable. And that's the way it typically goes down. The judge is going to just figure out something that seems fair to the judge, and that's going to be the temporary injunction. And you're probably never going to get to a trial after that, in most cases.
Because things settle.
Yeah, because for a couple reasons. One, because they settle. Two, because a lot of times, by the time you get to trial, the non-compete has expired.
Oh, interesting. And let me ask you this, Zach. So my next question was, typically, is it true that if you get sued for violating a non-compete, there are not going to be monetary damages? There's just going to be that, what we call as lawyers, specific performance, saying you can or cannot do something, but you're typically not going to have to pay your employer back money. And let's keep trade secret stuff out of it. But just on a non-compete, is that generally right?
Well, no, you can get damages, but it's a little bit tricky. So let me explain how that works in a non-compete lawsuit. The Texas non-compete statute provides for 3 potential remedies: reformation, which we were just talking about, an injunction, which we've talked about, and damages. Okay. By the way, side note, it does not allow for recovering attorney's fees. And even a lot of lawyers get this wrong. Well, it doesn't allow for the plaintiff employer to recover attorney's fees. Okay. Now, the employers and their lawyers will often assume they can recover attorney's fees because, as you know, in general in Texas, you can get attorney's fees on a breach of contract claim. Not true in non-compete law. So anyway, side note. But yeah, so you've got damages, injunction, reformation. Those are your potential remedies. Here's the thing about damages in a non-compete case, and this is a big advantage potentially for defendants. So the people who are arguing against enforcement of the non-compete. If the court finds the non-compete unenforceable as written, it can reform it, but then it cannot award damages. And specifically damages that occur before reformation. But just to put it in simple terms, if the court finds it too broad, no damages. Okay. Now that's a huge issue, right? Because a lot of judges seem to struggle with this. Like they don't, because it puts them in the position of making a hard decision, right? Because they have to decide enforceable, not enforceable. And if it's unenforceable, they're pouring out the plaintiff on damages for the non-compete. So big issue. And usually they don't want to have to decide it. They'll punt that or kick the can down the road as much as they can. But at some point, they're going to have to decide legally, is it enforceable or not? And if the employee wins that argument, no damages. So that's
okay. So what's an example of where the employee does have to pay the former employer damages in connection with the non-compete?
Well, here's what will typically happen. The most common damages theory is going to be lost profits. So it would be the former employer will say, okay, you took jobs from 10 of my customers, and here's the profit we would have made on those jobs if you had not taken them from us. And in many cases, they'll get a hired expert, usually a CPA, to do that calculation. And they'll call them a damages expert, which in my view is not really a thing, but that's what they usually do. Now, there's an obvious potential flaw in that kind of calculation, and the flaw is this: it's causation in a word. But the flaw is, well, how do you know those 10 customers all would have gone to you for this work, right? Especially when the person they dealt with left, right? What if they had gone to a third party for this work? How do you know with any reasonable certainty they would have gotten this service from you? And we make this argument all the time.
Sure.
So that's the basic problem with non-compete damages.
Right. Fascinating. Golly. Okay. So what I'm gathering here is, I think, people need to, like you said, it can be just a document slipped in the welcome packet, which you absolutely can and should say, hold on, I'm going to take this home and read it, or have my attorney read it, or my attorney brother-in-law, somebody get some eyeballs on it, because unless you read it with a lens toward, in other words, you sign up, it's the job of your dreams. You're excited. It's great money. Of course you're going to take it. And of course you're going to sign a non-compete if that's what they're going to mandate. But, and this is where lawyers, the sky is falling. You have to say, all right, the honeymoon's over. Something happens. You want a divorce from your employer. Happens all the time. Can you deal with what is in that non-compete, and because it comes up. And so to kind of turn a blind eye, and they don't expire, right? Unless they say in the document, all right, if you're here for 10 years, then there's no, I've never seen that. I don't know if you have, but these are real documents that have real teeth that can have real economic and emotional implications for you. And so it's really, really smart to give them the due diligence they deserve on the front end, just to save yourself a lot of grief on the back end. And to your point, sometimes you can work with them on some of the terms, sometimes you can't. But either way, you gotta understand what you're signing. And I think that getting an attorney, and I talk people, I don't need an attorney for this, do this, that, and the other. But for something like this, to read it with a legal eye is very, very important, just because it is your livelihood, in your life. So I think it's worth buying an hour or two of an attorney's time to at least explain worst case scenario to you to make sure you still want to sign it.
Yeah, I think that's generally good advice. But I will say this. When we get contacted by potential clients in this situation, and they're like, hey, I've got, my employer wants me to sign this non-compete, can you take a look at it? The first thing I do, I send them a blog post I have called, should you hire somebody to look at your non-compete? And I basically, I kind of try to persuade them not to, which is, I know sounds strange, but here's what I mean. In the article, I explain that if the employer is not going to negotiate the terms, and if you have no choice but to sign it, you may not want to spend your money on me, because I can tell you, yeah, I don't like this, I don't like that. I mean, I don't, but if it's not going to matter, you might just say, well, I guess I just have to sign it.
Yeah, and ignorance is bliss.
So I send them that first, and then after looking at that, if they still want the advice, then of course they'll engage us and we'll give them that advice. And that is, I mean, I don't want to be too down on people getting legal advice. You're right. As a general rule, it's a good idea. I mean, it's not going to hurt you to get some legal advice up front other than the cost.
Well, and it may just hurt your feelings, because when you're excited about this job, it's everything you wanted, the next step of your career, and then you shove the non-compete in front of your lawyer, and he rains on your parade and tells you why your employer is so bad and all this stuff. You got to be prepared to receive that advice or that information. So,
that makes me think of some other advice that clients usually don't like hearing, but it's the reality. And that is on the other end of the relationship. Let's say you signed the non-compete, you worked there for a while, it went south. You said, I don't want to work here anymore. You get an offer from a competitor and you go work for the competitor. Then the first employer sends what I call a nasty gram, sometimes, called a cease-and-desist letter. And they send it to you and your new employer. And next thing you know, new employer, HR at your new employer calls you up and says, listen, I hate to tell you this, but we really like you, but we really this company doesn't like litigation, and we're just gonna have to let you go. That can happen. And that sucks, because as a lawyer, I can't do anything about that. I can't make them, stand behind you and fight with your former employer.
Yeah, that's a tough one.
And you just have to be prepared for that possibility.
Yeah. Very interesting. Zach, thank you for all of this wealth of information around non-competes. I know that anybody listening to this is going to go, wow, these go a lot deeper, a lot more aspects to them than I realized. And we didn't even really get that far into the trade secrets and confidential information, which is whole other stuff. So everybody go read Zach's blog, The 5 Minute Lawyer. And what is it, 5minutelawyer.com?
5minutelaw.com.
5minutelaw.com. There's a ton. You've been writing that blog for years, and it's just like a mini law school about non-competes and trade secret wars and all that jazz. So lots of information there. So go check it out. And thanks again for spending part of your morning with us.
Oh, Brooke, thank you for inviting me. I was so thrilled to get the invitation. This was a lot of fun.
A lot of fun. All right. Well, have a good rest of your day. And again, life is legal, so you got to know the rules.